Hello, my name is Alex Proctor, and I'm the Chief Trust and Privacy Officer at Captain Compliance. Welcome back to another video covering the world of modern privacy litigation. Now, if you happen to watch my recent video all about wiretapping lawsuits, you may have picked up on an important theme. There are some very old laws that are being used to litigate very modern website practices of today's businesses, and it's costing them millions of dollars. Now, in that last video, there was so much to cover on the wiretapping topic alone that I didn't have time to get into any of the other creative ways that plaintiffs are going after businesses and their websites. However, the truth is that there's still more that you need to know if you are going to protect your company. That's why in this video, we're going to be breaking down the Video Privacy Protection Act. This is a 1980s law with a private right of action, and it's being aggressively used to bring privacy cases against companies to this day. I'll give you some background on the law, we'll look at one or two notable cases, and then we'll focus our remaining time on risk mitigation actions that your company can take. Before we dive in, I want to offer a pair of reminders. First, it should go without saying that how you set up your website has significant legal implications. You need to make informed choices about which third-party tools to use, how to configure them, and how to present your privacy notices and consent options. My goal here is to provide context around these choices and just to share practical steps you can take to reduce risk. Just remember that your own legal team should definitely be engaged in this territory. Second, if you're not already aware, this is an area where Captain Compliance can really help your company. We can significantly reduce your VPPA risk exposure with dynamic privacy notices, granular consent controls, and other key aspects of our privacy platform. If you're interested, we'd be thrilled to have the opportunity to support you. I'll put contact information in the video description. Okay, with all that said, let's dive into the VPPA. The VPPA actually has a pretty wild origin story. It's not going to help you understand the modern implications of the law, but it will help you understand the original intent of the law at the time that it was passed. Back in 1987, President Reagan nominated Judge Robert Bork to the Supreme Court. This was somewhat of a controversial nomination for many different reasons, including for Bork's views on the subject of privacy. The nomination was getting plenty of publicity in the fall of 1987 as the Senate was conducting their confirmation hearings. Around the same time, a journalist named Michael Dolan, writing for the Washington City paper, discovered that both he and Bork were regulars at Potomac Video, a video rental store in Washington, D.C. Dolan got an idea. He approached the assistant manager at Potomac Video and managed to obtain a list of 146 videotapes that Bork had rented over the prior 2 years. Apparently, his goal was to dig up something embarrassing about Bork and to publish it during the confirmation hearing in order to damage his reputation. After obtaining the rental list, Bork reviewed the titles, wrote his story, and ultimately published the Bork tapes. Now, the ironic thing about this whole episode is that, by all accounts, Bork's rental history was actually pretty tame. The list didn't include any R-rated videos or anything else that could have been easily weaponized against him. The list was mostly a collection of action, mystery, and adventure movies, particularly of the British variety. Even in the absence of scandalous rental data, Dolan still chose to smear Bork, mostly just based on the fact that he rented a lot of movies. In fact, Dolan suggested that Bork was well suited for the job of supreme couch potato. Anyway, when this story was published, it ignited all sorts of controversy. Members of Congress were concerned about their own privacy, and they were seemingly pretty motivated to pass the Bork Bill, more formally known as the Video Privacy Protection Act, about a year after the incident. The VPPA created strict rules around video rental records and imposed steep penalties for unauthorized disclosure. As for Bork, he never made it to the Supreme Court. The Senate ultimately rejected his nomination in the fall of 1987. Well, the Bork tapes incident doesn't seem to have been the primary reason. It certainly didn't help his case. So that's the backstory of the VPPA and how it came to be. Let's take a few minutes to consider the basic requirements of the Video Privacy Protection Act. The law is quite short and easy to read, so it's going to be pretty straightforward for me to highlight the most important pieces that you need to know. As you would probably expect, based on the backstory of this law, the VPPA's stated purpose is to preserve personal privacy with respect to the rental, purchase, or delivery of videotapes or similar audiovisual materials. The heart of the law can be found in Section B1. It states, a videotape service provider who knowingly discloses to any person personally identifiable information concerning any consumer of such provider shall be liable to the aggrieved person for the relief provided in subsection D. Now, we'll cover the penalty structure later, so you'll understand what sort of relief that the statute is referring to. At this point, I just want to cover a couple of terms that are doing the heavy lifting here. All of these definitions are going to be extremely relevant when we start to focus on how the law is being applied to websites and tracking technologies. A consumer means any renter, purchaser, or subscriber of goods or services from a videotape service provider. That definition seems pretty straightforward, but something that you should know is that in the modern website tracking context, there's going to be some debate about exactly what constitutes a subscriber. Next, a videotape service provider means any person engaged in the business in or affecting interstate or foreign commerce of rental, sale, or delivery of pre-recorded video cassette tapes or similar audiovisual materials. This is another VPPA definition that you're going to find is open to interpretation. Obviously, we're not here to be thinking about cassette tapes. So the key words in the definition are going to be similar audiovisual materials. Is it possible that online videos qualify? According to some courts, the answer is yes, at least some of the time. We'll get into that later. The final important definition is personally identifiable information. The statute defines PII as information which identifies a person as having requested or obtained specific video materials or services from a videotape service provider. So, first and foremost, this is obviously narrower than the traditional definition of PII because it's focused on video materials. Another one of the key phrases in this definition is where it says information which identifies a person. This is where courts tend to split when it comes to website tracking because it's possible to argue whether technical network, device, and application identifiers can truly identify a person. More on this later. As for the rest of the VPPA, it does contain a variety of exceptions. I'm not going to spend much time on them. Just know that there are certain common sense situations where disclosure is permitted. For example, disclosures can occur with a consumer's informed written consent, or to law enforcement with a proper court order. There are also exceptions which are intended to cover the original course of business activities. These cover situations like debt collection or order fulfillment, and the general theme is that there's some flexibility to share names and addresses, so long as the disclosure doesn't involve sharing details about specific video titles. Now, let's talk about penalties and enforcement. I already told you, the VPPA is a bit unusual because it provides a private right of action, meaning that consumers can sue providers for violations. This is pretty much the entire reason that this law is relevant to website tracking cases today. I described in my last video on SEPA that many of these modern privacy laws do not include that private right of action. Plaintiffs need to get creative if they want to sue companies for website privacy violations. This is why the VPPA, along with the old wiretapping laws, are being used for this purpose. Anyway, VPPA remedies are spelled out in the law, and they are significant. A prevailing plaintiff can recover actual damages, but if those are difficult to prove, The law guarantees liquidated damages of at least $2,500 per violation. On top of that, the courts can award punitive damages, attorney's fees, and costs. This structure makes VPPA claims particularly attractive to plaintiffs' lawyers. Okay, now that we've gone through the VPPA in detail, let's talk about how it's been repurposed in recent years to target website tracking practices. Here's the core idea. For several years now, plaintiffs' lawyers have been making the argument that when a website offers video content and simultaneously embeds certain tracking tools, like the metapixel, those tools can facilitate a disclosure of video watching activity under the scope of the VPPA. For example, if a consumer watches a video on a website and some tracking pixel quietly sends details about that video, along with other identifiers, to a third party, it can result in a situation that the plaintiffs say looks a lot like the unauthorized disclosures that the VPPA was designed to prevent. This argument has fueled a wave of VPPA lawsuits targeting news publishers, streaming services, sports leagues, and even retailers that host product videos on their websites. In fact, over the past few years, this theory has driven hundreds of VPPA lawsuits annually. Now, this may feel like a stretch to you, and that's exactly why the courts have been split. They have not been ruling uniformly when it comes to these modern VPPA cases. Some courts have been willing to entertain the arguments. Others have pushed back on this creative method of applying the VPPA. I've already hinted at some of the divisive issues earlier. They tend to be questions of whether a defendant is truly a videotape service provider, or whether users actually qualify as subscribers under the statute, or even whether the identifiers being shared, which can be technical things like browser settings, device IDs, and IP addresses, should actually be considered personally identifiable information in the first place. The main thing to know right now is that legal enforcement of the VPPA is currently somewhat unpredictable, and website litigation risk is very real for companies that stream or embed video content on their websites. If your website isn't configured in a privacy-conscious manner, there's a possibility that you may face claims that your pixels, cookies, and other trackers are illegally sharing the modern-day equivalent of a VHS rental receipt with third parties. Now that you're up to speed on the general trend, I'd like to review an active VPPA case together. The most high-profile VPPA lawsuit that we've seen to date involves the NBA. Salazar versus National Basketball Association was originally filed as a class action lawsuit in the Southern District of New York all the way back in September of 2022. In this case, the plaintiff, Michael Salazar, had signed up for the NBA.com email newsletter, which required him to provide some personal information about himself. At first, this little detail may seem trivial, but the reason that it's important is that Salazar would later use this to support the claim that he was a consumer under the VPPA. Remember, the definition of a consumer can include subscribers of goods or services from a videotape service provider. After signing up for the newsletter, Salazar browsed the NBA website and watched some of the video content available there. Think basketball highlights, interviews, and the type of video that you'd find on the NBA website. You can probably see where this is going. Salazar would later rely on a claim that the NBA qualified as a videotape service provider under the VPPA. What really triggered the VPPA litigation was the discovery that NBA.com had installed a meta tracking pixel on their website. The lawsuit alleged that this pixel transmitted information about the videos that Salazar watched without his consent back to Meta. More specifically, the claim was that this shared information was personally linkable, meaning that Facebook IDs or other unique identifiers could be used by Meta to specifically associate Salazar with his NBA video watching history. As a side note, I'm not really looking to do a deep dive on the metapixel right now. Just know that when it comes to social media tracking pixel litigation, it's at the top of the list. The NBA obviously pushed back on the VPPA allegation, and the case was initially dismissed by that Southern District of New York in August of 2023. The court found that the free NBA email newsletter subscription, consisting of non-video content, wasn't sufficient to qualify Salazar as a subscriber under the VPPA. However, this was only the beginning of the case. The district court's dismissal was appealed, and arguments were considered by the Second Circuit in 2024. The Second Circuit ended up reversing the district court's dismissal. The key aspect of the reversal was the Second Circuit's decision that goods and services under the VPPA are not restricted to audiovisual materials. So, in simpler terms, their interpretation was that subscribing to any of the offerings of a videotape service provider, even non-video related offerings, was enough to qualify an individual as a subscriber under the VPPA. Now, you may be wondering if the NBA should even be considered a videotape service provider in the first place. This wasn't an element of the case that was being appealed. The Second Circuit didn't formally decide whether the NBA was a videotape service provider. It left that issue for further proceedings. I do want to note that some courts have taken a conservative stance there, suggesting that businesses need to be more heavily engaged in the business of video rentals to qualify as providers under the VPPA. Speaking of differences in interpretation, one thing that I haven't told you yet is that Michael Salazar actually had more than one VPPA case in the works. He had also filed a similar lawsuit against Paramount Global and their website 247sports.com around the same time that he had filed the NBA case. In the Paramount case, which was also dismissed and appealed, the Sixth Circuit rejected the broader interpretation of a consumer and pretty much took the opposite stance that the Second Circuit did. The court found that the VPPA only protects subscribers to audiovisual goods and services, so the newsletter subscription didn't qualify. This Sixth Circuit decision occurred only a few months ago, in April of 2025, so there's some possibility that it could represent the start of a trend favoring a narrower interpretation of the VPPA. Now, back to the NBA case. This is where things get even more interesting. The NBA petitioned the Supreme Court, and the case was docketed in March of this year. The Supreme Court is being petitioned to take the case, and even the National Football League has stepped in alongside the NBA to try to get this case heard. Obviously, there could be major implications here. A favorable decision could result in hundreds of VPPA cases being dropped. Throughout the year, there have been various filings being completed in anticipation of the Supreme Court deciding whether to take the case. Maybe I should have waited on this video so that I could tell you how this one ends. If the Supreme Court does take the case, the outcome could set a nationwide precedent, either shrinking or massively expanding VPPA liability. I'll definitely have to do a follow-up in the event of one of those outcomes. In any case, here is the takeaway for you. The courts are willing, at least in some jurisdictions, to stretch the VPPA far beyond its original VHS rental context and into the world of online tracking and analytics. That doesn't mean that the plaintiffs will always be successful, but it does mean that companies need to take this law seriously, especially if they operate websites or apps that heavily feature video content. Even more so if they're running higher risk tools like the Metapixel. This law is a powerful tool for plaintiffs' lawyers because even something as ordinary as embedding a pixel on a certain type of website can potentially lead to liability. Okay, so if I've done my job so far, I've conveyed what the VPPA is, what the litigation trends look like, and why it's important for businesses to be aware of the risks associated with online tracking tools. I now want to pivot and talk about how companies can avoid as much of this litigation risk as possible in the first place. I'll warn you up front that my first recommendation may not be practical for most companies, but I do want to point out that if all things are equal, you're probably better off with a smaller surface area for litigators to go after than a large one. What do I imply by this? Quite simply, if you're not getting business value out of tools like the Metapixel or TikTok Pixel or LinkedIn Pixel, it may not be the worst idea to simply not use them. You can also make similar points about your session replay tools, which are very relevant when it comes to SEPA and the other wiretapping laws. At the very least, you should know exactly what tools are on your website and how they are configured. You should understand if you're operating in a way that could be challenged in the courts. I do recommend getting into the weeds here. Make sure that you know when your pixels and analytics tools are firing and what information they're actually sending to third parties. Make sure that you understand if video data is being shared. In some cases, you actually do have some configuration options that you can use to limit your risk. Now, assuming that you do choose to use these very common tools, understand that it is generally possible to use them in a privacy-conscious way that aligns with the privacy laws and also builds customer trust. The two main themes here are going to be notice and consent. When it comes to notice, you need to make sure that your privacy disclosures are crystal clear about the fact that video interactions on your site may involve the collection and sharing of data with third parties. A generic privacy notice that simply mentions cookies or tracking may not be sufficient if plaintiffs' lawyers come knocking. The courts expect to see disclosures that are specific, accurate, and aligned with how your tools are actually configured. On the consent side, you'll want to think carefully about whether you should be obtaining opt-in consent before any sensitive tracking occurs. For example, if you're embedding a pixel that can transmit video watching history, that's the type of activity that may call for informed consent, above and beyond the passive opt-out consent that's often available in cookie banners. Now, I bring this up all the time. There is an unfortunate tension between the modern privacy laws, which tend to allow for opt-out consent, and some of the case law on the litigation side, where courts have expressed the importance of affirmative opt-in consent. Every US-based company should consider this tension when deciding whether they're going to use opt-in or opt-out consent models here in the States. Anyway, the main theme is that giving users clear notice and choices about the tracking that can happen when they watch videos can reduce your VPPA litigation risk while also improving transparency and customer trust. My final recommendation is to avoid treating this as a one-time project. Websites are pretty dynamic. Tools update, configurations change, and new integrations get added to websites all the time. A best practice is to implement ongoing reviews so that you always know what data your site is sending to third parties and when it's sending it, and whether it still aligns with your notices and consent flows. Companies can get in trouble here simply when they don't have the visibility about what their own websites are doing behind the scenes. To sum up my recommendations, limit your surface area where you can, use strong and specific privacy notices, try to rely on opt-in consent for higher risk tracking, and maintain oversight of your website's data flows. Taken together, these steps can go a long way towards keeping your company out of the VPPA crosshairs. And the best part is they also go a long way in reducing wiretapping litigation and even regulatory compliance risk. Okay, we've reached the end of the video. We've conducted a pretty deep review of how the VPPA is being used to target modern companies into their websites with expensive privacy litigation. I've also drawn some parallels with the wiretapping litigation that's also sweeping the country. As a reminder, I do have an entirely separate video covering wiretapping lawsuits, so if you liked this one, check that one out if you're interested in more information about the overall privacy litigation landscape. In addition, we've also reviewed how companies can reduce their VPPA risk exposure by offering strong notices and disclosures, as well as by offering privacy choices and consent options to website visitors. If your company needs support mitigating VPPA or wiretapping litigation risk, Captain Compliance is standing by and we're ready to help you. Our platform is designed for the very purpose of simplifying compliance and reducing these sort of risks. We can help you meet the high standards of transparency and consent that we've already discussed today. The reality is that these privacy lawsuits are only accelerating, so if you're not ahead of them, you're already behind. We're here to keep your company out of court. If you need more information, please feel free to reach out to me or visit our website. It's www.captaincompliance.com. I'll put the link as well as additional contact information in the video description. Thanks for watching.